And that is the risk of due process, that you can't present your case because it's farther away than your home county, where you could easily present your case, again, with no reason except the state's arbitrary whim as to why you should have to file it there.
You know, what we explained in the opening brief is that the General Assembly sort of looked at the rise in constitutional litigation over the last 5 years, often in kind of cases by litigants asserting essentially parallel or substantively identical claims in courts all across the state. So, for instance, the litigation against the assault weapons ban, the litigation against the Safety Act, and concluded that it would best serve the public if that litigation was centralized in the first instance in the counties that house state government, which are Cook and Sangamon.
Well, your opponent argues that the Attorney General has attorneys throughout the state, so it wouldn't inconvenience you to defend in another county, would it?
Of course, and that's true. We do have regional offices across the state, and so we're really not here kind of relying on the sort of difficulty to our office. But the General Assembly looked at this problem, and it concluded that the kind of most reasonable response to it was to take this litigation, which was being filed in sort of these disparate courts across the state, and bring it to courts that had substantial experience with the kinds of public law issues that arise in these cases. And it adopted, and you can look at the sort of floor transcript for this, it adopted a model that it has used before. There are, 15 or 20 other statutes that say if you want to bring sort of administrative review law challenges to decisions of the government, you have to do that where the government lives, in Cook or Sangamon. And so what the sponsor said is, we're just going to import that principle from these administrative review statutes into this principle too. And we don't think that that violates due process principles as a general matter, for the same reasons that it doesn't violate due process principles in those cases either. And it's hard, I'd be hard pressed to say how the court could affirm the circuit court's opinion here while not raising questions about those statutes as well.
By forcing my client to litigate in a foreign venue, foreign jurisdiction, foreign being a different county, and therefore making it far more difficult for my client to present his evidence in support of his fundamental claim. Obviously, the farther away from the court in question, the greater that would be. As relates specifically to my client, that's, like I said, it's basically a full day for any witness, some witnesses are easier to get to appear than others. Documents have to be transported. Of course, on applying the foreign nonconvenience law, this court has said moving documents is relatively easy, and truth be told, it is, but it is far more difficult to litigate hours away from your home forum than it is in your home forum, especially when there is no compelling interest or reason to force you to litigate in a foreign jurisdiction or foreign county, except that the state does not like being sued in different states or different counties.